Before I came to Congress, I spent 30 years down at the courthouse in Houston, the criminal courts building, which I dubbed the Palace of Perjury. And I spent that as time as a prosecutor and then as a judge, a felony court judge, hearing criminal cases, everything from stealing to killing and everything in between. Because of that experience, I spent a great amount of time dealing with the U.S. Constitution, primarily the Bill of Rights and primarily the Fourth Amendment. To give you a little background and then address the specific issues that we have here today, back in colonial days, the British were determined to make sure that goods brought into the United States were not smuggled, because if they were smuggled, the colonists didn't pay the tax that was due the king. So they had came up with an idea to search the colonists, primarily just their businesses and their homes, to see if any of those smuggled goods came in without paying the tax to the king. And they invented this document called the Writs of Assistance, which was a flowery term for a general warrant where the British military could go into someone's residence or business and look for really anything, but primarily looking for smuggled goods where people didn't pay the tax that was due the king. This irritated the colonists a great deal. After all, they did have a war of independence. One of the reasons was because of the Writs of Assistance. And after the war was over, we got our independence from Britain. We wrote a constitution, and then they came up with a few Bill of Rights, 10 of those, that really had their founding and purpose to prevent government from intruding the right of privacy of specific individuals under the new country called the United States, which led to the enactment of the Bill of Rights, primarily the Fourth Amendment. I have it up here on the podium. I guess if I was high-tech enough, I would have it here on the screen, but it's on a poster. And I will read to you the Fourth Amendment, and you can look at it. There's a lot of provisions in it. Volumes of legal treatises have been written about the Fourth Amendment. Volumes. And we're not going to have a law school indoctrination on the Fourth Amendment, but let's just read it and then see how it applies to today's society in 2014. The right of the people to be secure in their persons, their houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by an oath or affirmation, and particularly, describing the place to be searched and the persons or things to be seized. What that means is this, that if law enforcement wants to search something in your residence or in your effects or in your property, the officer that wants to do the searching must go before an independent magistrate, the buffer between law enforcement and the citizen, and swear out an oath, under oath, a warrant to search a specific place for a specific thing or person. That's on the back end of the Fourth Amendment. It has to be very specific. It has to be specific enough under our law that if the judge signed the warrant, the judge could give the warrant to a different person, and that law enforcement officer could read this warrant, know exactly where to go, know exactly what he's supposed to be seizing, and who he should be arresting if there is an arrest. That's how specific the warrants have to be today. And that was the reason the Fourth Amendment was written the way that it was written. But the purpose is to secure privacy of the individual. So let's use a hypothetical. It's not specific, really too specific, but it's a general hypothetical that I would like to just talk about. We have two notorious outlaws in Texas. That's where I'm from. One of them is Ollie Oglethorpe, and the other one is Bobby Joe Oglethorpe. They are bad guys. They are bank robbers. They rob people. They rob banks. And let's say that they decide to come to Washington, and they plot and scheme to rob the Congressional credit union over in the Longworth building. They go inside, they rob the place, they take the loot, and they make away their escape and get away. And they hide somewhere in Washington, D.C. That's all we know. They're not captured. But we know probably that the two individuals are somewhere in Washington. So if law enforcement decided, okay, we're going to go get Ollie Oglethorpe and Bobby Joe Oglethorpe, we know they're in Washington. They would go to a judge. They would say to the judge, we know they're in Washington. We know they're in zip code 20003. But that's really all we know. We would like a warrant to go into all of the places in zip code 20003 and find Bobby Joe Oglethorpe and his brother Ollie, and most importantly, get the loot. There is not a judge that would sign the warrant to allow law enforcement to go into every building and residence. We all know that's absurd. There is no way that would occur because the residence or the place in the warrant is not specific enough to go to that location and find the Oglethorpes and or the money. That would be a general warrant. That would be warrants that maybe the British would have imposed back in colonial days, because the Fourth Amendment prohibits that type of conduct. However, let's assume that the Oglethorpes have spent some time on the internet discussing this criminal activity, discussing where they're going to hide, where they hid the money, and some of their other criminal enterprises. If law enforcement had probable cause to believe that occurred, then they could go to the appropriate judge and get a specific warrant and maybe go to one of these folks here and get that information, their emails. But let's say they don't have probable cause. They just don't have enough information to convince a judge they have probable cause to believe the information is there that they're looking for. So what do? They wait 6 months. And all of a sudden, on 6 months and 1 day, without the use of a warrant stating probable cause, they may seize that information without probable cause because the law says you can seize it. Now, one would think that that's absurd, that just because it is 6 months and 1 day, that the warrant requirement should not be required. But that is currently the law, because the law was written too long ago to keep up with modern technology. The Electronic Communications Privacy Act, as Julian said, was written in 1986. The internet and all of our electronic knowledge and storage has changed since then. So, because of that, Zoe Lofgren and myself and others have sponsored one piece of legislation, and there's other pieces of legislation where members of Congress have signed on to fix that problem and guarantee the right of privacy if email storage is over 6 months old, stored in the cloud somewhere. Will the Supreme Court, independent of this legislation, will the Supreme Court rule that you have a reasonable expectation of privacy if your emails are stored over 6 months in the cloud? I don't know how they would rule. I really don't. That's why it's up to Congress, has the responsibility to legally state there is an expectation of privacy, because that is the key phrase under our law and under the Fourth Amendment. What is the reasonable expectation of privacy of the citizen whose information or property or papers is being seized? I don't know what the judges on the Supreme Court would rule. They may say, you don't have a reasonable expectation of privacy. There's people in law enforcement say, you don't have a reasonable expectation of privacy. We want to seize all that information. And then there's others who say, yeah, there should be a reasonable expectation of privacy. We can debate that issue theoretically forever. So Congress must come in and say, yes, there is a legal expectation of privacy when your emails are stored in the cloud. Go back to the situation with regular mail. It's now called snail mail, I guess, is what it's called. Some of us still use snail mail. You know, of course, if you're writing a letter to someone and you seal the letter and you put the stamp in it, over it, you actually give that letter to government. And government sends that letter all over the country until it finally reaches your mother-in-law's house. But there is a general expectation of privacy in the contents of that letter. Sure, there are exceptions. We're not going to talk about the exceptions. But there's a general rule: government cannot go into that letter and read what you're writing your mother-in-law. Can't do it. Well, what if the government hangs on to that letter for 6 months? Well, does that change your reasonable expectation of privacy? Probably not. And this is going to not a private company. It's going to government. Has the duty to protect your right of privacy. Emails, they're not going to the government. They're going through a server, through a private enterprise, through a private corporation. That should be even more protected, not less protected than regular mail. Why? Because it's not in the possession of the government. It's in the possession of a private entity. But yet, if government waits out the 6 months, then they can seize all of that information through the cloud. I think that's a violation of the Fourth Amendment, and I certainly think Congress should weigh in on this issue to make sure that it's a protected right under our Constitution and legislatively.